On December 12th, 2025, something extraordinary happened that most news outlets either ignored or fundamentally misunderstood. Russia's central bank filed a single lawsuit seeking 18.2 trillion rubles in damages from Euroclear in Moscow's arbitration court. Welcome back to Norton Investigates, where we dig deep into the stories that mainstream media overlooks, exposing the hidden mechanisms of power, money, and geopolitics that shape our world. If you're new here, we specialize in breaking down complex international events into understandable analysis that reveals what's really happening behind closed doors. Now, on the surface, this might sound like routine legal posturing, the kind of thing governments do all the time when they're upset about sanctions. But what I'm about to explain to you reveals this move as perhaps the most sophisticated demonstration of asymmetric legal warfare in modern international relations. With this single filing, Russia effectively weaponized the international legal system to neutralize the European Union's elaborate four-year scheme to confiscate $210 billion in frozen Russian sovereign assets intended for Ukraine funding. In one masterful stroke, Putin transformed what appeared to be Russia's greatest disadvantage into devastating strategic leverage that has now paralyzed European decision-making and exposed fundamental vulnerabilities in Western financial architecture that nobody wanted to acknowledge existed. This legal maneuver represents far more than routine litigation or diplomatic posturing. It constitutes a masterclass in how authoritarian regimes can exploit the very legal frameworks that democratic systems depend upon for legitimacy. Think about that for a moment. Russia is using the West's commitment to rule of law as a weapon against Western interests. This is economic warfare for the 21st century, and it operates through courtrooms and legal precedents rather than traditional military or diplomatic channels. We are witnessing the emergence of a new form of state-level conflict where legal systems become battlegrounds and court jurisdictions serve as strategic assets, enabling smaller powers to neutralize the economic advantages of larger coalitions through patient, methodical exploitation of legal vulnerabilities that democratic institutions create through their own commitment to due process. The timing and precision of Russia's legal assault reveals sophisticated strategic planning that has clearly been years in development. Moscow waited for the optimal moment when European leaders had committed themselves so deeply to the asset seizure plan that retreat would represent political humiliation, while advance would require accepting potentially catastrophic legal and financial risks that could fundamentally undermine the European Union's credibility as a reliable custodian of international reserves. Russia's strategy exploits multiple simultaneous pressure points designed to force European decision makers into impossible positions where every available option carries devastating consequences for European financial institutions, political cohesion, and international standing. Now, let me explain why the target of this lawsuit matters so much. The lawsuit targets Euroclear, the Brussels-based central securities depository that holds approximately 185 billion euros of the frozen Russian assets. That represents roughly 88% of all Russian central bank reserves immobilized across European Union territory, making Euroclear the single most critical node in the entire asset seizure architecture that European leaders have constructed since February 2022. But here's what makes this so dangerous for Europe. Euroclear isn't just some random financial institution. It operates as the backbone of European post-trade financial infrastructure, processing over 42.5 trillion in custodial assets and serving as the primary settlement mechanism for pension funds, central banks, and commercial banks throughout the European Union. Any successful legal challenge to its operations would create cascading disruptions throughout European financial markets that extend far beyond the immediate question of Russian asset management. The Russian central bank's claim for 18.2 trillion rubles equivalent to approximately $230 billion at current exchange rates, encompasses not only the frozen funds themselves, but also lost profits, management fees, and opportunity costs that Russia calculates as resulting from Euroclear's unlawful actions in preventing Moscow from managing its own sovereign reserves. This creates a comprehensive damages framework that potentially exceeds the total value of assets under dispute. Russia's strategic calculation appears designed to transform Euroclear from a neutral financial institution into a geopolitical liability for the European Union, forcing Brussels to choose between abandoning its Ukrainian funding plans or accepting responsibility for potential legal judgments that could bankrupt one of Europe's most critical financial infrastructure providers. The lawsuit's filing in Moscow's arbitration court ensures that Russian judges will evaluate European financial institutions according to Russian legal standards and interpretations of international law. This creates jurisdictional asymmetry where European defendants must operate within Russian legal frameworks, while their own court systems lack reciprocal authority over Russian state entities or assets within Russian territory. This jurisdictional manipulation represents a fundamental exploitation of sovereignty principles that democratic legal systems respect, but authoritarian regimes manipulate, enabling Russia to weaponize legal pluralism against opponents who remain constrained by their own commitments to international law and due process protections. The preliminary hearings scheduled for January 16th, 2026, establishes a timeline that coincides perfectly with European Union budget planning cycles and Ukrainian funding requirements, creating temporal pressure that forces European leaders to make decisions about asset seizure before they can fully understand the legal consequences or develop adequate defensive strategies against Russian retaliation. Now let's look at what's happening inside Europe, because this is where Russia's strategy is really paying dividends. Belgium's resistance to the EU asset seizure plan has intensified dramatically since Russia's lawsuit was filed. Prime Minister Bart de Wever explicitly stated that European guarantees remain insufficient and warned that confiscation could trigger cascading failures throughout Euroclear's operations that would undermine confidence in European financial markets, while violating fundamental principles of international law that Belgium cannot accept responsibility for breaching. The Belgian position reflects recognition that Euroclear's global credibility depends on its perceived neutrality and reliability as a custodian of international assets, characteristics that would be permanently compromised if the institution becomes viewed as an instrument of European foreign policy rather than a neutral financial intermediary. Hungary and Slovakia have seized upon Russia's legal challenge as validation for their opposition to asset seizure. Hungarian Prime Minister Viktor Orban denounced the European Commission's emergency clause invocation as systematically raping European law and promised to pursue all available remedies. Italy, Bulgaria, Malta, and the Czech Republic have joined Belgium in opposing the reparations loan scheme, creating a blocking minority that prevents the qualified majority voting necessary to implement asset seizure. This internal European resistance demonstrates exactly how Russia's legal warfare strategy succeeds, not through direct confrontation with European power, but through amplification of existing divisions within European Union decision-making structures that democratic governance creates through its commitment to consultation and consensus building. The European Commission's three-tiered defense mechanism, designed to protect Belgium and Euroclear from potential Russian retaliation, reveals the extent to which Brussels recognizes the legitimacy and potential effectiveness of Russia's legal threats. Under this framework, European institutions would be permitted to offset losses from Russian legal judgments against other Russian assets held within European jurisdiction. But this mechanism itself acknowledges that European courts and financial institutions cannot simply ignore Russian legal decisions without creating reciprocal vulnerabilities that undermine the international legal cooperation that European financial institutions depend upon for global operations. Russia's promise to pursue all available legal and other mechanisms without further notice creates strategic ambiguity about the scope and timing of potential retaliation, forcing European institutions to prepare for multiple simultaneous legal challenges across different jurisdictions. The other mechanism's terminology suggests that Russia's response will extend beyond purely legal remedies to encompass economic, diplomatic, tools that authoritarian regimes can deploy more rapidly and with fewer constraints than democratic governments. Here's where the hypocrisy becomes glaring. European Union officials' dismissal of Russia's lawsuit as speculative and groundless contradicts their simultaneous development of elaborate defensive mechanisms designed to protect European institutions from exactly the kind of legal challenges they publicly characterize as frivolous. This contradiction between public dismissal and private preparation indicates that European leaders recognize they have created legal vulnerabilities that Russia can exploit effectively, but cannot acknowledge this recognition without undermining political support for policies that have been presented as legally sound. The European Commission's invocation of Article 122 emergency powers to indefinitely freeze Russian assets represents an unprecedented expansion of emergency authority that creates constitutional precedents future European leaders could invoke to bypass democratic oversight during other perceived emergencies. This constitutional overreach demonstrates how external pressure from Russian legal warfare forces European institutions to abandon their own legal principles in pursuit of geopolitical objectives, creating the kind of institutional degradation that authoritarian opponents seek to provoke. Now, let me explain the global implications, because this extends far beyond European-Russian relations. China, Saudi Arabia, the United Arab Emirates, and other major holders of foreign reserves are undoubtedly studying Russia's legal tactics as potential templates for protecting their own assets from political weaponization by Western governments, while simultaneously reassessing the risks associated with holding substantial reserves in jurisdictions where political considerations can override traditional custody protections. The precedent being established suggests that sovereign asset custody is no longer protected by the legal and institutional frameworks that have governed international finance since Bretton Woods, creating incentives for major reserve holders to diversify away from Western financial institutions toward alternative custody arrangements that provide stronger protection against political appropriation. This diversification process, already visible in central bank gold purchases and alternative payment system development, will likely accelerate as the Russia-Europe legal warfare demonstrates that even the most sophisticated Western financial institutions cannot guarantee the security of client assets when those institutions become instruments of government policy. Russian success in weaponizing international legal systems also provides a blueprint for other authoritarian regimes to exploit democratic commitments to rule of law and due process, potentially creating cascading legal challenges across multiple jurisdictions whenever Western governments attempt to impose economic sanctions. The Trump administration's 28-point plan proposing distribution of frozen Russian assets among Ukraine, Russia, and the United States represents American recognition that European asset seizure plans have failed, and alternative arrangements must be developed that bypass European institutional paralysis. American pressure for European asset seizure simultaneously weakens European political cohesion while providing Russian legal warfare with additional legitimacy as a defensive response to American financial coercion. When I project forward from current trajectories, I see European leaders trapped between impossible alternatives, where asset seizure creates potentially catastrophic legal vulnerabilities, while abandoning asset seizure represents political humiliation and strategic defeat. Russia's legal warfare strategy succeeds regardless of ultimate court decisions, because the litigation process itself creates sufficient uncertainty and institutional stress to prevent effective European action. The January 16, 2026 preliminary hearing will likely be followed by years of additional litigation across multiple jurisdictions as Russia systematically challenges every aspect of European asset management decisions. The profound irony of this situation cannot be overstated. Europe's attempt to use frozen Russian assets to demonstrate Western resolve and capability has instead revealed fundamental Western vulnerabilities that authoritarian opponents can exploit through patient legal warfare that turns democratic institutions against themselves. Russia's legal gambit represents not merely tactical cleverness, but strategic insight into the structural weaknesses of democratic systems when confronted by opponents who can weaponize legal pluralism against institutions that remain constrained by their own commitments to rule of law. The ultimate lesson extends beyond Russian-European relations to encompass broader questions about democratic resilience in an international system where legal warfare enables authoritarian regimes to exploit the very institutional characteristics that democratic societies consider essential for legitimate governance, creating systematic disadvantages that may prove decisive in long-term geopolitical competition. Future historians may identify Russia's Euroclear lawsuit as a turning point when authoritarian legal warfare demonstrated its capacity to neutralize democratic economic advantages through systematic exploitation of legal vulnerabilities that democratic systems cannot eliminate without abandoning the institutional commitments that define democratic governance itself. That's all for today's investigation. If this analysis opened your eyes to what's really happening in global finance and geopolitics, smash that like button and subscribe to Norton Investigates. We'll continue following this story as it develops. Until next time, stay informed and stay vigilant.